All right. Good afternoon or good morning, everyone, depending on where you're based in the world. My name is Morgan Taylor, and it's my pleasure to open up today's event on SEPs, it's essentiality checks. And this event is actually the second of a series of webinars organized by the App Association in light of the upcoming European Commission consultation on the new framework on standard essential patents. Billions of devices are connected through IoT technologies, which provide innovative firms such as our members with several avenues of growth every day. However, the standardization required to guarantee interoperability presents several obstacles in its implementation. And also, by means of today's discussion, the Association is committed to finding a balanced solution to tackle the various concerns which surround the determination process of SEPs essentiality checks, especially in the perspective of small innovative businesses, and with the purpose of supporting the EU policymakers to find the best possible solution, one that on one hand fairly rewards the investments made to create the standards, but also enables our members to use the standards efficiently and without concerns that doing so will create future legal headaches. And for this discussion, I'd like to hand it over to Jim Beveridge, IP Fellow of the Innovators Network Foundation. I'm happy to leave it with you, Jim, and in your capable hands. You are an expert moderator and have done lots of work and great work on SEPs. And I'd like to thank all the panelists and, of course, the audience. And I'm looking forward to a fruitful discussion. Jim, the floor is yours.
Well, thank you, Morgan, and for these opening words. And a very good day to everyone. My name is Jim Beveridge, and I will be the moderator of today's event entitled The Essentiality, Validity and Infringement of Declared SEPs. So the focus of today's discussion stems from the relentless drive of technology, which is resulting in a burgeoning number of declared SEPs. Today, it's just not telecom-orientated organizations that hold SEPs. The number of SEP holders has more than doubled in the past 10 years across a number of technical domains. The rise in the number of SEP holders has gone hand in hand with the growing number of self-declared patents, with the number of patents rising from some 82,000 in 2010 to around about 305,000 in 2021. And according to the industry watcher Iplytics, these stats confirm that the number of declared patents in 10 years has more than tripled. Now, these patents are declared, but these patents are not necessarily essential. And therein lies the issue that we plan to examine in today's panel. Consider the innovative SME addressing the growing IoT market with a standards-compatible product, confronted with several thousand potentially relevant patents per standard. In these cases, any manufacturer will have difficulties determining with reasonable effort which declared SEPs he needs to license, and whether these patents are essential and legally valid. Now, this is a daunting enough task for a large multinational. What chance does an SME have? Connectivity will impact all vertical market sectors. SMEs in the ICT sector are moving to further support smart cars, smart energy, smart factories, smart healthcare, and the smart home. As they do so, they will increasingly rely upon connectivity standards that are subject to SEPs. They will need to face the complex licensing world surrounding that. Avoidance isn't an option. And a vibrant digital ecosystem will be an important source of innovation and choice in European digital products and services. Crucial will be multi-dimensional access to patents and standards data that underpin these new technologies. For this afternoon, to shine a light on these important issues, we've assembled a panel well versed in the practical issues surrounding SEP licensing, and in particular on the hot topic of essentiality. Before we move on to the panel, some practical remarks on logistics. Today's panel session will be structured in two parts. In a moment, each of the speakers will be invited to give a brief opening statement. We will then move into a moderated question and answer discussion, hoping to incorporate some of the audience questions. On the audience questions, to ask a question, please use the Q&A function in Zoom. Please do not use the chat function, as your question might well get lost there. Please post your question at any time during the event, and these will be collected and directed towards the relevant speakers. Please note that any question related to ongoing litigation will not be answered in this forum. So I'm excited to introduce today's virtual panel, which will consider these practical issues that small businesses face when licensing SEPs. They will examine the policy changes being advocated to address these issues, and finally opine on the pros and cons of the various solutions being proposed. The speakers will take us through the issues surrounding current essentiality assessment procedures based on their own backgrounds, providing industry, academic, and legal perspectives to the discussion. And you can see in front of you now the pictures of our esteemed panelists. So firstly, we've got Brian Scarpelli. Brian is a senior policy counsel for ACT, the app association, where he works on a variety of legal and policy issues impacting app development. These areas include intellectual property, broadband access, competition, and privacy. Prior to ACT, Brian worked for two telecommunications standard-setting organizations, the Alliance for Telecom Industry Solutions, ATIS, and the Telecom Industry Association, the TIA. Secondly, we have Professor Joachim Henkel. Joachim is a Professor of Technology and Innovation Management at the Technical University of Munich. Joachim has authored various papers on SEP issues and has notably contributed to a pilot study for essentiality assessment of SEPs, which investigated the technical feasibility and subsequently made recommendations for a system to ensure better essentiality scrutiny for SEPs. Next, we have Professor Nicholas Thum. Nicholas is a Chair of Innovation Economics at the Technical University of Berlin, and like Joachim, has also contributed to the pilot study for essential assessment of SEPs. Previously, Nicholas was Senior Fellow at the European Commission's Joint Research Centre in Alicante, and until 2013, he was Chief Economist at the European Patent Office. And finally, it's my pleasure to introduce you to Giuditta Caldini. Giuditta is an associate at Latham & Watkins LLP in Brussels. Giuditta advises clients on cases involving all areas of EU competition law, including abuse of dominance and restrictive practices. She has acted for clients in a broad range of sectors, including technology, media, healthcare, and digital sectors. On our panel, she will offer a unique antitrust perspective on SEPs due to her extensive background in competition law. So now let me turn to the panel discussion for an opening statement to set the scene, starting with Brian. Brian, one issue small businesses face when licensing SEPs is whether declared SEPs held by the patent holders are actually essential to a standard. What are essentiality checks? At what point are they done in practice? When should they be done ideally? And why is this an issue for SMEs? Brian, over to you.
Thank you, Jim. And hello, everyone. I'm very pleased to be here. Again, my name is Brian Scarpelli, Senior Global Policy Counsel with ACT, the App Association. Just a little brief tangent about our organization, who we are, and why we care about this issue. We're ACT, the App Association. We're a not-for-profit global trade association that represents more than 5,000 small business connected device and software application and Internet of Things technology development companies located around the world and across Europe. I think our community more than any other, I think, needs certainty in the standard system itself and in SEP licensing in order to know that they can rely on standardized technologies to innovate and compete across consumer and enterprise verticals. And we're more acutely, I think we, the small business community, as Jim was mentioning a moment ago, is more acutely impacted by SEP abuses because we don't have the resources and not just money, but staff, time, et cetera, to sustain years of litigation and delay related to the exploitation of ambiguities in today's SEP licensing ecosystem, which I think lends to SEP abuse. So we welcome this opportunity to engage on essentiality, validity, and other aspects of the SEP licensing ecosystem here today. I think there's a broad range of issues and solutions that rest at different points in the standardization value chain, if you want to call it that, that can contribute to this needed certainty and predictability in standardization and SEP licensing generally. I think on the topic of essentiality and validity, that those areas are no exception. And solutions rest throughout. I think standards that, the idea of an essentiality check, some kind of trustworthy, fair, impartial, ideally body providing an assessment of whether a patent declared essential to a standard is actually essential to that standard. This is something of an ideal today, and there are a lot of practical issues before I think we would get there, which I don't mean to get out in front of my fellow panelists that I think you'll hear about in a second, but I do believe that I would suggest that standards bodies themselves can help a good amount. The standards bodies themselves often require that companies participating in the development of a standard disclose to the standard setting organization that they have patents or even patent applications that they believe are or may become essential to the standard. I think a standard setting organization's fair, reasonable, non-discriminatory patent licensing policy will require that disclosure and adherence to those terms by the contributor, the patent owner, is incredibly important. Especially because they know their patents the best. Yet at the same time, a challenge is that the standard setting organizations can't independently corroborate whether a declared SEP is actually essential to the final standard. And I think we should also just to put out there for comment thought, we should recognize that there seems to be a systemic practice of over declaring essentiality in the standard setting process, and this over declaration can reduce transparency and certainty, and I would argue is probably why we're here talking about. In part, why we're here talking about the need for essentiality checks to begin with. Many declared patents are eventually found non-essential. That it's actually quite staggering, the statistics. So I'd suggest that SSOs themselves should play a role in addressing these issues. At a minimum, SSOs should adequately document licensing commitments that are relevant to potential standard essential patents and that will facilitate the discussions within the standards process and encourage updating with relevant information where appropriate. So while standards setting organizations, I think, can and should take steps to generally address proper SEP licensing behavior, including with respect to essentiality checks and patent validity, I think transparency more broadly should be prioritized in the context of negotiations that later occur after the standards process has concluded and a standard is finalized and in the market and being used. So I would suggest that any good faith SEP holder who's approaching a potential licensee should provide sufficient explanations and bases for all of their claims, and provide adequate information that will allow that potential licensee to assess whether a patent is valid, whether it is essential, and whether they need to take a license, and whether the SEP holder's offer complies with the FRAND commitment that's attached to those patents. So patent or patents. And, I think just a couple other things to mention very quickly is that in that process, another item that I hope comes up and that, I'd love to hear other panelists' thoughts on, et cetera, is the use, or I would argue overuse, of non-disclosure agreements, in that negotiation process. I think there's no disputing to me that while that parties can choose to keep some information that's relevant to a negotiation confidential, that's a normal commercial practice. But there's basic information that can be very important to facilitating a FRAND licensing negotiation that does not require confidentiality. And in my view, that information should be provided for upfront by an SEP holder who's approaching a prospective licensee. I think that there's a very helpful resource that at this point I think is time tested, a cross-industry collaborative best practices document developed under an open and transparent framework offered by CENELEC, that provides best practices throughout all of these steps in negotiation and standardization before that. In SEP licensing, it's called CWA 95,000 for short, and it provides, I think, a lot of helpful detail on the types of non-confidential information that good faith SEP holders should be willing to provide to prospective licensees. Ultimately, I think we are talking about essentiality checks, and I think we'll hear some very, very good information about the European Commission's pilot, I expect, and things like that. I'm not trying to get out in front of the other speakers. Once again, I would just suggest, that what we should strive for is that any independent third party essentiality check or assessment on essentiality is able to truly avoid bias and embodies fairness, right? An ultimate determination in the end. I think that the option needs to be there for taking that decision to a court of law, and I find it difficult to impugn a party for preserving the right to go to a court when one's talking about willingness or unwillingness and things like that. So I think it's important that we collaborate and learn, I think, from the great work that you will hear about in a second, on especially with respect to essentiality checks. And I think current, efforts, development of tools can be very useful in helping us, all of us, understand in our community the benefits, challenges, the potential for essentiality assessments. I think that as an entity, I know we're, like an organization like the European Commission, I think has a role in helping clarify perhaps how essentiality checks should be determined. But I know that it can be complicated here, and there's a number of landmines to avoid. I think there's a number of important issues for the entire community impacted by SEP licensing to come together on and find some consensus on, probably before before there's some kind of some sort of mandate or something like that for third part for essentiality checks. But a government entity like the European Commission has a very important role. So I look forward to exploring that today. Thank you again. I hope I have not gone on too long with my opening remarks and stop there.
That's all. Okay. That's great. Well, thanks, Brian. So you've actually teed it up nicely for Joachim. You mentioned the European Commission's pilot study, and Joachim, you co-authored that pilot study and suggested that the Commission pursue the development and implementation of a system for essentiality assessments. It'd be great if you could present the summary and implications of this study. And additionally, based on the fact that we spoke earlier on, and you mentioned that you've been around quite a number of SMEs, actually understanding what the SMEs were up to and some of the issues they faced. So it'd be nice if you could use the opportunity also to maybe bring in some of the actual practical examples to how people are, and how SMEs in particular are being impacted by the issues that Brian raised there.
Yeah.
You, Joachim.
Thank you, Jim, and more than happy to do so if I manage to do in the time frame. But I'm also open for questions. So thanks very much for having me. Thanks for the invitation. And let me share a few slides. I can't speak without slides. So, and also I think it's worth investing a few PowerPoints here. So this is about this pilot study for essentiality assessment of standard essential patents that you mentioned, which was commissioned by the European Commission. SEP licensing. The efficient licensing of SEPs is important, obviously. I mean, for smartphones, but increasingly so for the IoT. And of course, SEPs may relate to other things like video compression, not just wireless standards, but they are obviously super important, and we'll focus on those here. There are frictions, as already Jim and Brian have mentioned, due to, well, a couple of uncertainties regarding essentiality, regarding but also infringement. Even if a patent is essential, it may not be infringed because standards have optional parts. Validity, that's a general problem with patents. And in the end, what's the appropriate royalty? There are many question marks still. Essentiality is arguably particularly problematic because the only thing, or the starting point we usually rely on, is declarations, and they are made by patent owners. They're made by parties with an interest, and for all sorts of reasons, they may declare too many patents, partly innocuous reasons, but it's just a fact. One study by Goodman and Myers found that even 80% of the patents in their sample were not essential. Other studies are somewhat lower. But even worse, there's also strong variation between firms. Because if all had 50-50 essential, non-essential, we could live with that, but it's also strongly different. Study by Cyber Creative for LTE found variation between 17 and 68% being non-essential of the declared SEPs. And if you look at smaller portfolios, as sometimes enforced by patent assertion entities, you can expect an even greater variance. So question, can that problem be addressed systematically? And that was the topic of the study here that was repeatedly mentioned. And there are many authors here, and in particular, Rudy Beckers as the first author, and I believe the driving force behind this thing, who invested in enormous effort and a lot of knowledge, should be mentioned. I'm also an author, obviously, but also many other people contributed a lot here. That study has many aspects. I will just focus on one here, and I recommend this to your reading, on the technical feasibility of this assessment procedure and also the institutional feasibility. Briefly, acknowledgement, we had great support by a number of stakeholders, particularly the patent office, a couple of patent offices, but many others. This is very gratefully acknowledged. Briefly, the team here, as you see, a lot of people, different countries, different backgrounds, different activities, including a lot of people also from industry that were supporting us. The core thing I would like to speak about here is an experiment where we just tried out essentiality assessments. So what the setup was, we had a sample of cases. Cases were combinations of a patent document with a standard document. To create these cases, we had 45 unique patents and 48 unique standards documents. Some of these cases we provided to the people doing them with claim charts and others not. The patents were 3G, 4G, and the European patents. And here's an important point that distinguishes our effort from earlier ones. Because earlier studies, well, partly they're very diverse. They don't say a lot about their methodology, but also we have no idea about any benchmark. So how close or not close are they to the actual essentiality rates? What we did, we used patents that were evaluated by patent pools based on the assumption that patent pools actually do a very careful analysis of if a patent is really essential before they include it into their pool. So we use that as the gold standard, and what I can report now, or will report, is consistency with the patent pool's assessment. We take that as the gold standard. That can be criticized, but you need to have something. You can't wait for every patent to be decided about in court. Examiners had, assessors, the assessors assessing those patents by essentiality had about 7 hours per case. And here is just one example of the results. There are many tables in the report, also in an academic paper we are currently developing, which shows here for the case of, not the case, but for cases without a claim chart and with a claim chart. With the claim chart, we reached best results, or not we, but the assessors. So 83% of the cases they assessed were consistent with the assessment by the patent pool, which is not perfect. So 100% would be better, but I mean, the pool may have gotten it wrong itself, but also, well, there's probably room for improvement. So in any case, we think we can say that technical feasibility is given. An essentiality assessment on a larger scale is technically feasible. And in particular, since probably if you really implement that, you can expect further improvements due to specialization of people on parts of a standard, learning effects, access to outside sources, which is what we denied assessors. They should really only look at the documents they got. You could also allow challenges like opposition and appeal. An important other point, I mean, technical is nice, but institutional is there demand for that? Are important stakeholders willing to contribute? That seems positive as well. So many stakeholders expressed an interest in transparent data on essentiality. Implementers, patent owners, courts, SDOs. So there is at least broad support for having this. It's not quite clear who does it, but that's at least given. If you implement it, you have to make a number of design choices, obviously. So here they are. I'm not going into details. So again, I recommend the whole report to your reading. We marked 3 of them, B, D, and F, as most promising. And as also Jim already said, we have a couple of recommendations for policymakers. Let me just name one, namely, they should pursue the development and implementation of a system for essentiality assessments, simply because otherwise it's in every licensing deal, it's again the same old story of which of these patents is really, this is just an incredibly waste and inefficiency, which creates lots of frictions into an important process. A couple of other recommendations I'm not going to go into. So concluding benefits and limits of that, they're definitely benefits. So it's a good thing to have that. To have a list, ideally, just a list on the web of these patents are essential for LTE A or something. That should make SCP licensing more efficient. It also increases legal certainty. If you have closed a contract or a licensing contract, at some point, I've covered all. Oh, that's unlikely, but most actually essential patents, and also reasonable royalties can be assessed in a better way. But the important limitations, and that refers to the point that Jim mentioned, for IoT firms, so firms outside telecom, uncertainty about essentiality is a problem, but it's just one of several problems. And here comes in this research that, Jim, that you mentioned briefly. So this is entirely unrelated to the European Commission study that I co-authored. It's a scholarly paper. It's not supported by any institution or firm. It's just research, because I'm interested in finding out how actually, it's called How to License SEPs to Promote Innovation and Entrepreneurship in the IoT. And here I'm pretty pessimistic. So firms outside the telecom industry, of course, they don't know about essentiality, but they also lack technical skills to evaluate, for example, technical merit. They have no idea about who actually owns these SEPs. Some of them don't even know what they are. They typically lack understanding of rent, and especially SMEs and startups. And it's those firms that we want to innovate in the IoT space. And I've heard incredible stories. It's really amazing what firms do there, but they often don't even know there is an issue. So often my interviews end with teaching them SEP 101 because they just don't know. They happily buy modules and install them. They couldn't do this. So even if they had information about essentiality, they could not get into licensing negotiations with an unknown number of patent owners. They don't have the legal competence. So my conclusion is from this research, certainty about essentiality is to them, in IoT in particular to small and medium enterprises and startups, of very little help. It helps other people, it helps the big guys, and that is good. It's just for the small guys, it doesn't work. So I'm pretty convinced device level SEP licensing, which is what many SEP holders push for, that doesn't work for SMEs. If you're interested, please read more. There's the paper, there's the abstract, and you can get, the slides are available after the talk. And if you're interested, send me emails. Thank you very much. And back to Jim.
Okay, Joachim, well, thank you very much for that insight into the pilot study, and of particular interest in also in your findings with these SMEs. So turn now to Nicholas. Nicholas, it would be useful if you could get your reaction to what Joachim put forward there. But also, one of the areas that's quite contentious just now is in the establishment of an independent system for essentiality assessments. So should there be any feature in particular which should be integrated into its development to make it fair, i.e. the implementation of any precise requirements to determine essentiality? It'd be good to gain your views on that. Over to you, Nicholas.
Okay, thank you, Jim, for the introduction. And thank you also to the previous speakers for their very useful insights already. I hope you can hear me, and thanks a lot in particular to the organizers for inviting me to this event. It's a pleasure discussing these issues here with you. So in a nutshell, if my takeaway from Joachim, from the SEP essentiality pilot, where I was also involved as an editor and the person who actually set up the whole project by the time, is very humble. I mean, it's saying, yes, testing of essentiality is technically and institutionally feasible. But however, the success of such a system will much depend on the specific design and how this is going to be set up. And many elements were already risen. So it's a trade-off between the price. So of course, how much is it going to cost? I mean, how much are the costs that are involved? And that depends a lot on the quality. That's the second element, the quality that you can provide. Joachim mentioned, you can spend, well, the examiners spend on average 7 hours, but not all of them, of course. Some spend more, some spend less. And also that is, of course, related to the quality of the examination that you will receive, but it's also related to the costs that are involved. I mean, this is billable hours in a way. And then very important in the context we're discussing this, that is the trust that is actually put into the outcome. And that is much related to the organizations that take care of such an assessment. And I will say a few more words in a second on that. But I think actually this last element is maybe one of the most important ones in setting up such a system, if we get to that. And so, and I'm grateful that the European Commission is pursuing this matter. Generally speaking, there is multiple elements, of course, that have to be considered. I mean, so transparency, that is also in the process of setting up such a system, is very important, of course. It should be publicly available. We have an operating system in this with pools, which is generally not publicly available for good reasons. It should be harmonized. I mean, this is something, of course, so at least what the Commission is aiming at is probably a system for the scope of the geographical scope of the European Union. Well, that makes sense, but also we would have to think beyond that if we get to anything like essentiality tests. It should be kind of approved. So there has to be a quality kind of approval, so that if different entities are involved, I mean, then of course they should do the same work. It should be comparable. It should be, that was mentioned a couple of times, SME friendly, clearly. And I mean, there should be an important element is also the quality of the data that get into and out of such a system. It's very important in this context. The pilot study already revealed a lot of insights, but I think around that, probably to set up a system, there is a lot of additional information is still required. I mean, we still lack of consistent data as for cost per license, time to negotiate, actually the costs that are really involved in essentiality testing right now, ongoing, the surge in information costs on the other side. I mean, Joachim mentioned some people don't spend time on that, but others do spend time on that. And okay, what is the time and what is the effort? What are the costs that are involved in actually looking for the SCPs that are relevant to me? The real cost of essentiality, that's a core element, and the validity examinations in these contexts, still the litigation costs, claim chart costs, all of that. I mean, all of that somehow needs to systematically still be analyzed in order to get a consistent picture in combination with the information that is already there. And that will somehow lead to whatever will be the outcome. I think at a minimum level, I would expect something like the creation and maintenance of a central database where, you know, all the elements are put together, the information on the one side, but also the surrounding information, but also the SCP relevant information. Of course, the independent system for third-party essentiality checks itself. And then there should probably be, since it's so politically, biased also, and so there should be somehow a supervisory body to control the assessments, and or a kind of observatory, something around that makes sure that actually all of this is going to happen the right way. And again, Joachim mentioned this already, and I just wanted to highlight that from the study, we can already see some of these elements. I mean, so for instance, also I would like to raise your attention to the costs. And in that respect, I mean, for instance, the element to which extent such a system should be self-financed or maybe state subsidized. I believe that the relevance of and the use of artificial intelligence, that's also mentioned in the report, but I want to stress it here again, is very important. That can, of course, reduce costs. It's at the moment probably not yet developed sufficiently, but it is for sure that for any system, previous pre-checking with AI, with the help of AI, would and could be very, very important. And then, of course, around the who should do that, we'll get into that probably a little later on. Again, that is very, very important. I mentioned that before with respect to the trust that people will have in such a system, and in the context of the pilot. So who was involved? It's been the European Patent Office and some national patent offices. And that's probably a very good starting point. But of course, it should also be open, towards the people that are already active on the market in this respect. Otherwise, in other contexts, we have had also, there's an element of competition, because in a way, this is going to offer a service that is already existing on the market. So, these elements have to be seriously considered from the policymakers when we're going to discuss that. And I would now just like to raise more questions than providing you answers. And that is by briefly referring you to the paper that Ruud Peters and I were publishing in the Intellectual Asset Management magazine earlier this year. And we provide some answers, our answers here to the questions. But I would focus here, for the sake of time, just more on the questions, because I think in the context of what we're discussing here, they are very, very important. So again, what entities are best placed to perform essentiality checks? Patent offices, obviously. The SDOs were mentioned. So Brian, you said, well, I mean, actually they should at least, be responsible for part of the data, of the maintenance and so on. I think, yeah, you probably have a fair point there, but to which extent? And also, of course, the IPR policies, to which extent do they have to adjust in order to make it happens? So there is probably a role by SDOs to be played, but to which extent and what exactly, all of that has to be defined. And again, the existing professional service providers, so the pools, what about them? And others, maybe, right? Or newcomers. Maybe this is also a business opportunity for people that haven't even thought about, getting into active in this field. So question number 2, what should be the legal status of the outcome of an essentiality check? I mean, also that was kind of addressed already. Is it mandatory? Is it something voluntary? What are the jurisdictions? Is there a new jurisdiction? Is there any jurisdiction at all? It should be open to court at the end, definitely. Appeal opposition procedures and so on. All of that has to be carefully thought through. How can the cost for essentiality checks be kept at a reasonable level? Now, that is very important, of course. We can think about, doing checks for the whole of ETSI database. And I think we were discussing that also in the context of the PALIS study, which would be a tremendous amount of of input. And I think nobody would want to pay for that. Nobody would want to carry this out and probably it's not even required. But within a patent family, which patents would you want to address if you want to go for checking, which ones not? Important decisions here to be taken. And also, if you look at the countries where you want to address, which are more important to you, so which are probably more representative in the context of your patent family for essentiality checking, and so on. So a lot of questions here to be answered. And then, so that's actually a very important one to me. So who should pay for essentiality checks? It's not only the who should pay, it's actually also how should you pay. You could think about paying at the beginning when you pay a lump sum when you declare your SEPs being SEPs. And so a lump sum payment, this would happen somewhere at the beginning of the standardization process. You can pay when you ask for the service. At the end of the process, we're always talking, that's important, final standards in this context and final granted patents. I assume, I hope we all have a common understanding there. So, and of course, the how much is also very important. And that is much related to what I mentioned previously. It's the financial model that is run actually by different entities that are involved, the market entities. There it's clear. I mean, it's bill of lading, but with patent offices, it's not so clear because they run different financial models. It's also a lot depending on the subsidies they receive from government. So there one has to find a system that works for everybody, and that will probably not be so easy. What incentives could be introduced for patent holders to have essentiality checks carried out? Yes, I mean, here it's very important to consider the SME part that was already mentioned a couple of times. So how to get SMEs being also involved in this. There's probably a special SME status required if SMEs are really appear to be as SEPs holders in this context, right? Again, is it mandatory? Could you think about, putting specific incentives for SEPs holders so that that forces them into the system? We thought about some of these issues in the paper, you can find it. And and then finally, how should the process of setting up essentiality checks be started and institutionalized? I can see, and that's why we're all talking here, that this is in safe hands for the time being with the European Commission. Well, that is good. But of course, we should also keep in mind that, I mean, that the world is watching here, and that this is going to require international harmonization somehow. It's clearly a forerunner role here, so a role model that is going to be set up where others will be very closely watching what is going to happen. And I'll leave it with that, and just want to repeat what I said at the beginning, so that the nitty-gritty details will be important, and it's all around, I think, this equilibrium between price, quality, trust, and all the different elements that are mentioned. So thank you very much. I'll stop sharing my screen now.
Yeah, well, thank you very much for that, Nicholas. That was great. So turning now to Gudita, we've talked about the proposal to establish essentiality check systems to increase the transparency between SEP parties in a given marketplace. In light of this mission, do you think that installing systems for essentiality assessments will actually contribute to the transparency issue? And can you see any limits to establishing such of the systems that are being proposed right now? Gudita, over to you.
Many thanks, Jim, and many thanks to the organizers for inviting me to contribute to this very interesting debate. So perhaps I wanted to start by linking myself to something that Brian mentioned at the beginning, which of course, in the last couple of years, everybody has realized that the transparency in SEP negotiations is very, very low, that there is an inequality of arms between SEP owners and licensees. And I think a lot of us have been thinking about how we can make sure that transparency can be increased. And surely essentiality checks can be one way to increase transparency if properly implemented, and I will get to that in 1 second. But there is a lot that can be done already beyond essentiality checks to increase transparency, and perhaps those small tweaks and small changes to the SSO's IPR policies, I think, would bring us a long way. So, for instance, we can already see that by requiring SEP owners to identifying specific IPR claims and specific IPR applications for their SEPs, that would necessarily increase transparency, give potential licensees a lot of information that today they might not have. And that is something that the European Commission can definitely help with in making it a requirement for SSOs to include in their IPR policy when reviewing the horizontal guidelines. And we know that this is something that they've been thinking about, and that they have been asking stakeholders to comment on. So just to say that essentiality checks are, of course, something that we should focus on, but there are a lot of other small tweaks that can be done that will increase transparency and might not have the complications and the potential drawbacks of essentiality checks. So I very much agree with Brian, on that. Now, about essentiality checks, as we have heard from all the other panelists, this is something that can definitely help the SEP world to have increased transparency, but there are some risk associated with establishing essentiality checks. And I think to understand what those risks are, we should take a step back. I think Joachim did a fantastic job of explaining how the system works, but essentially, because patent holders declare essentiality to SSOs, they obviously have an incentive to over-declare. And I think I saw some stats, and Joachim, I think he had similar stats of 1 in 8 declared SEP is actually not essential or valid in court. So of course, we have an issue of implementers having to start negotiations when for SEPs that might end up not being valid or essential. But we also have a court system that has been overseeing this and doing a great job at it, since we see that there are stats that say that indeed court look at this and actually say that SEPs are not valid and are not essential. So we do have a court system, and I believe that we need to be careful in, establishing, potentially establishing a system for essentiality checks, which is extrajudicial and might actually bind the court. I think that would be a very, very problematic, and we should not go down like that route. So I think that is a big risk. Another big risk would be to have a system that is not independent, because everybody's got different incentives. As I've mentioned, SEP owners obviously have got an incentive in over declaring patents. It just goes without saying. So if we leave it up to them to check whether their own patents are essential, you would imagine that nothing would actually change. And so it is important to have a look at, who is going to be in this body to check essentiality. And I think that an independent, well-funded body would be needed. Another, big important point is that anything that would come out of this essentiality checks in terms of opinion, Nikolaos was talking about an expert opinion, of course, I believe should not be binding on the courts, because the court should continue to play their very important and final role in SEP disputes. And so anything that comes out of this check should not be binding. And more importantly, or equally importantly, it should not result in any legal presumption as to essentiality, so that we can continue to check what the experts have said. And similarly, it should not shift any of the traditional burdens of proof. So we don't want to see now that, let's say, a standard essential patent has been declared essential and has been checked by this body, and it is indeed essential, that this might mean that proving infringement might become easier, or that this is seen as putting the potential licensee in a more difficult position, because it is now negotiating or in front of a court with a SEP that has been indeed checked to be essential. So to recap, I think a system of third-party essentiality checks should support FRAND licensing behavior and be subject to the appropriate safeguards. And some of those safeguards, could be being an independent and well-funded system, non-binding on the court, so that they continue to do their job and not result in any legal presumption as to essentiality, and not shift any of the traditional burden of proof that we have in our legal system.
That's great. Thanks, Guita. Thank you for your intervention there. So Jochen, can I turn back to you, because I understand you got some comments in Guita's intervention there, and also I noticed that there's an audience question just come in as we're moving into the next phase, which is the moderated questions, including audience questions. So if I could just for the audience just outline the question that came in. It said, in practice, unfortunately, we have problems with over-declaration, but also even worse with under-declaration, or sometimes no declaration at all. What can we do with these SSOs or consortia standards that have no or almost no declaration obligation? So Jürgen, that's something you wanted to answer.
Yes, thank you very much. It's a very important question, because I've been struggling myself with IEEE declarations, which are often blanket. That means a party just says, yes, we might have some SEPs, but we don't tell you which. ETSI is better in that regard. At least SEPs owners are forced to reveal which patents they think are essential. But then even there, it's often difficult also. So there may also be unintentional under-declaration. And of course, with things like Wi-Fi for IEEE, it's just we don't know. So then really every potential licensor is left to itself to determine from a list of patents what it should do with that. And that's, I totally agree with, there was Michael Schlöger asking that, very good question. This in the IoT space, and there's, of course, Wi-Fi is super important, and Wi-Fi IoT device makers have been approached by patent owners with lists of patents. They're completely at a loss. So there it would actually even be more important to have such a system. But in the first place, to actually force patent owners to at least tell why they think they have patents. And otherwise that whole licensing with such a fragmented ownership as we have it for large standards just doesn't work well.
Okay, thank you for that. And have you any points to raise? You asked for some points to raise to Guida's points. Have you covered that there?
Yeah, if I may. So Judith found this super interesting, your statement. If I got this correctly, then you said you find it dangerous to introduce extrajudicial systems and the courts take care of that. With all due respect for courts, but I completely disagree. Because the problem is that courts, obviously, they can only take on very, very tiny, small number of patents. It takes an enormous amount of time. It's very expensive, depending on the country, it costs a fortune, and small firms cannot afford it. And also, sometimes courts, again, with all due respect to courts, but I've heard judges say things about patent infringement that reveal a pretty large lack of practical knowledge. So saying, I mean, I've heard courts saying something like, well, there is the patent database, just look it up and you see which you are infringing. No, it's not how it works. It's close to impossible to do this. And so sometimes I think it's very important to have something outside that not only evaluates a bunch of patents per year, but really gives an overview of the entire standard. Thank you.
That's great. Well, thank you for that. Now, so we're moving now on to the moderated panel session after the opening remarks. So I'm turning now to Brian. I see you there. So Brian, transparency has been mentioned a number of different times. You brought it up yourself. So does this enhanced transparency, is that going to solve the issue for SMEs? If not, what should we watch out for and what safeguards should we be seeking to implement? Over to you, Brian.
Thank you. Yeah. So I think it's that the idea of enhanced transparency generally, and the enhanced transparency that is, hypothetically a well-functioning essentiality checks system could provide would be helpful. Given if we can keep it within some of the safeguards, I think we all seem to be acknowledging here some of the practical issues. But I think if you take a step back and kind of look at the broader ecosystem, the broader issues, this is one piece of a number of areas where I think greater certainty, clarity is needed. That clarity can be provided, I think I was saying something similar earlier, in some ways by standard setting organizations themselves, and other ways by government enforcement authorities, in some ways by courts. But, for example, I mean, we can have in incredible transparency. We could have 10 times the amount of transparency we have today if that's not going to, in my view, change much on its own. Some of the systemic abuses that we continue to see in the standards and SEP licensing ecosystem, such as flat out refusals to provide licenses to good faith, willing licensees who come and seek them based on from that SEP holder who is flatly refusing to license some arbitrary characterizations, such as where they reside in a value chain. Now, whether or not that SEP holder is being transparent about what patents they hold or whether they're valid or essential is not going to help that SEP licensee who in good faith is approaching an SEP holder for the license they need to provide indemnities and assurances to all of their partners in their own value chain. It's not going, it's one piece of the puzzle for sure, but there are definitely broader, I think, systemic issues. And that's my answer to kind of, my answer is to go up to 10,000 feet, where I think there's a need for some clarity other aspects of what the FRAND commitment means. The idea that that non-discriminatory means non-discriminatory. Sadly, we're still debating that in a number of contexts. The idea that injunctions and prohibitive orders, exclusionary remedies, should only be provided to in limited circumstances when a FRAND commitment has attached to an SEP. The idea that a FRAND commitment follows an SEP in a transfer. Yes, sadly, we're still debating that. What a reasonable rate for calculating a royalty would be. So I think enhanced transparency can assist in a number of these other areas, but there are many other areas that I think deserve attention as well. It's some. I'm giving you some kind of a qualified answer there, somewhere between yes and no, Jim, about whether enhanced transparency will solve the issue for SMEs. I suppose it will help, and it will certainly enhance transparency. Will certainly help in a number of ways, but there's also a number of other ways where I think some more certainty and clarity is needed.
Yeah. Thanks, Brian. It sounds like it's part of the toolbox of solutions. As many standards organizations like toolboxes of solutions in when progressing their standards.
Yeah. And, something else I meant, I think it was an interesting exchange earlier. I'm sorry, I meant to add this, interesting exchange earlier there about deference to courts and perhaps I think various court systems may have their limitations, but I do think maybe a solution. I don't know if you agree with that, but would be some cross-stakeholder effort, consensus on some of these topics that can kind of make all boats rise. And I know I'm raising it for a second time in already, but I really do believe that there's a role for that cross-sectoral and cross-stakeholder agreement on that will normalize FRAND behavior. And I believe that is represented in that CENELEC housed CWA 95,000 SEP licensing best practices document that speaks to, I think in some pretty good granular, in a granular way, a very detailed way, the transparency theme and what behavioral norms should be. And maybe courts can use that.
That's great. Thanks, Brian. Now, Joachim, let me turn back to you then. I noticed you've spotted a question from the audience that you'd like to address. In addition to that, I was going to ask you, what do you believe will be the impact on SMEs should an independent essentiality system be developed? Do you think it's going to be a force for good for the SMEs? But also, if you could just enunciate that interesting question that came in from the outside party, that would be appreciated. Thank you.
Thank you very much, Jim. Yes, happy to. So let me start with your question, the impact on SMEs. As I said in my talk, if it's SMEs outside the telecommunications industry and it's licensors, so device makers in IoT, typically, I think the essentiality check just adds a little solution to a huge problem. I think it doesn't solve the problem. As I said before, I think there are all sorts of reasons why it just doesn't work to do device level licensing for SMEs in the IoT space or in any other space for that matter. Even worse for Wi-Fi if nobody even knows which patents are declared to be essential. 3 other points briefly. Coming back to Juditha, your point about extrajudicial instances or bodies that play an important role here. Well, in a sense, so does the patent office. It's also not judicial, but they decide about a very important thing, namely grant or denial of a patent. You can challenge that in court at some point. At least the grant, you can challenge patenting in court. But again, this is per se, it's extrajudicial. And so if, for example, in the best case, I think the patent offices did this assessment of essentiality, that would be just on the same level, in a sense, even less important than the question of grant. So I don't see a big problem, big difference between that. I would agree with you if it's about private firms doing that. I would be skeptical there too. Another point, Brian, you mentioned also that there are broader problems, and that brings me to the question in the Q&A by Alexandra Bielinski, saying that in most, well, actually more general too, in most portfolio of patents, there's typically a few of them that make up most of the value. So it's in mathematical terms, it's a highly right-skewed distribution. So very few make up a lot of the value. And your question was, why not focus on those? Why just focus on essentiality? The answer is that's even harder for determining, but you're right. In principle, it would be really good to do that. And it partly happens in licensing that somehow is taken into account if a portfolio is kind of above average value or below. There's some indicators, forward citations that a patent has received. They are a common indicator of patent value, but it's of course not perfect. But to understand really on the patent level what value a patent has technically, you would need to see how it really fits into the overall standard. And also, as you wrote, what are outside options, which alternatives could have been chosen, how much worse are they, or could a certain component of the standard have been dropped? But that is even a dimension more complicated, I think, than essentiality, because there you essentially compare the patent with a standard document and look for maybe an alternative invention. I think, yeah, these were my comments, I think. Thank you.
Okay, thanks, Joachim. So Nicholas now, so the European Commission and its expert group and the European Parliament, its IP action plan, has asked for the establishment of an independent third party assessing the essentiality of SEPs. So the $64,000 question is, who do you believe would be the suitable third party to perform these checks? And looking at the evolving role of SDOs in providing transparency in patent portfolios and the essentiality of patents, what role do the SDOs potentially play in this moving forward?
So thank you, Jim, for that question. If you allow me, I'll address a few other issues that were already on the table. So then it's getting a bit more interactive.
Go ahead.
Okay. So the first, I apologize for apparently my slides not moving. But most of what is important I have said. So if you want to find the reference to the article, I understand that the slides are shared by the organizers then. So again, sorry for that. Slides were moving on my screen, but apparently not on your screen. So sorry for that. Second, I think, Judita, you've mentioned a set of very important things that also Joachim already was referring to. I think we all agree that courts definitely will have the last word always. We're not going to change the judiciary system in that respect. But Joachim, very fair point. If you look into the samples that are in the pilot study, I mean, what the work that courts have been doing, I mean, I agree, it tends to be miserable. I mean, as for examination, not at all comparable to what is done within pools, or also the work that was done in the context of the pilot study. So there, a lot of the quality work as for essentiality testing could be improved a lot. However, I mean, I remember the discussion I had there once on a panel with Judge Meyer Beck from Germany, so that he clearly said, well, we're not going to look into any other, essentiality tests from elsewhere. And so we always want to look at this on ourselves. But I tend to disagree with Mr. Meyer Beck in that respect, because I believe that actually, I mean, any system that is going to be set up, of course, should aim at becoming a reference point for courts. I think that is very important in this context. Not saying that the courts will have the last word. They can certainly look into it, but simply their search and their examination will start at a much higher level. And that is important. So we're going to raise the overall quality in this context of SEPS examination also within courts. I think that's important in this context, right? Then Also, fair point. I mean, patents examined, Joachim, by patent offices. I mean, that's the legal status may be equal, comparable to, you know, what essentiality tests are. That's also what I'm myself always saying. However, I want to remind, of course, that with patent offices, if you take the European Patent Office, of course, that's all embedded into a very sophisticated legal environment. So the European Patent Convention and so on and so on. And that, of course, is still missing when we look into essentiality tests. So I wouldn't want to raise the bar so high that say, okay, we come up with detailed legal regulation and so on. There has to be something. But I would like to aim at a more practical approach at the beginning and then leave all these legal implications maybe for a later point in time. Not, of course, considering what you correctly pointed out, not getting into legal implications as for burden of proof and so on and so on. So I think that's very important to keep in mind. Joachim, also your point as for SMEs are actually they're not going to use this system. So why should we set it up? I mean, I tend to agree and not to agree. I mean, from a practical point of view, you're probably right. I mean, many SMEs are not into that business at all, but some are, as we have heard from Brian, and we cannot simply ignore, you know, the existence of the patent system and all the legal implications because a lot of SMEs are not capable of coping with the system. I think that's a very dangerous point to make here. I hope I maybe I misunderstood you, but I think it's really I think I'd like to push the SMEs into this, but you know, at a very low level so that it's easy to get into, and I hope that whatever is going to happen will actually facilitate that type of process. So that's the way I would look at it. So Jim, sorry, there was a long introduction. Now I'm getting to your question. So
you're covering good points, so continue.
So the SDOs, their role is or let me start with something else. I think I do agree with some of the people that was mentioned earlier that what we have here in the context of IoT, it's not anymore, and that includes your, not knowledgeable SMEs, Joachim, of course, that we have something that I would call a public interest, because IoT, makes these type of technologies, accessible to everybody, and everybody somehow touched or may be touched by SEPs. And very few people actually know about SEPs. I mean, I think we agree all on that. So what to do about that? And that simply means that for me is a very strong reason to say that, yes, the involved actors should become active. And that does, of course, also, so it's the state and the governments, the European Commission and the related governments, for instance, but also the involved actors. So that partly might be actually the SEPs holders. So, polluter pays. So, you're putting SEPs on the market. So you have to contribute somehow to make all of that transparent. But then, of course, also the host organizations that are related to this. And that's a tricky question, Jim. So what is the role, what could be the role of SDOs in this context? I would put the minimum level where discussions are right now about maintenance, updating of databases. They have to change if essentiality checks are going to be somehow operated. They will have to change their IPR policies. There will probably have to be new databases, and so on and so on. So at that level, I definitely would say yes. I mean, SDOs, they have a very important role to play here. As for the examination process itself, they have no resources. I mean, and they probably do not have the technical expertise. So I would put a big question mark to that, to which extent they should be involved into any of these examinations here. I mean, it's simply not practical, I believe, but it does make a lot of sense to be involved via the stakeholders, so the SEPs owners that are all represented with the SDOs, and then the whole data management, maintenance, where they will have to play a very important role.
That's great. Joachim, you've mentioned that you want to respond to some of that. Please go ahead.
Yes, briefly. So, Nikolaus, indeed, I did not say and I did not mean that we should ignore the patent system. But what I'm saying is what I found in my research, and I did like 20 plus interviews now, is a system where every SME, and that includes not just 10 people firms, M can be pretty large, if they get a letter saying you infringe on these patents, it just doesn't work. I mean, they're totally at the mercy of the patent owner asking for a fair amount. Of course, it then also invites then possibility that they just refuse to license, and then whatever may happen, we don't know. But I'm just saying it doesn't work. It might actually lead to the fact that innovation is mitigated. It's really slowed down. I'm not saying ignore the patent system, of course. I'm saying, and that refers to what Brian said before, this discussion about the licensing level. I also interviewed SEP owners because I really wanted to see both parties, and I'm grateful to every interviewee. They have their reason that they should get, of course, a good return on their risky investments in technology. But I don't think licensing on the device level, and certainly not for smaller and medium-sized firms, is the way that works. So it should be done at some higher level in the value chain. And policymakers have, of course, and then all marling over this, they have, of course, means to push into that direction. And I think that should be done in the interest of innovation.
Full agreement
Okay.
with you. Thanks.
So, ladies and gentlemen, time is whizzing on, and we're a few minutes now before the closing section takes place. So I've got a couple of things. I've got a final question to all the panelists I'm just about to give you, but also if there's something you want to say in response to what's going on as well, then feel free to throw that in. But we'll start in reverse order. And the final question is, based on your understanding of the issues at play, what is the one action you would like to see prioritized in order to move the essentiality issue forwards? And we'll start with Guida at the end. Give you the floor, Guida. What was the one action, everything you've heard, what is the one action you would like to see take place in order to move this issues forward?
The one action, I think probably identifying who's best placed to do such essentiality checks, because I think at the end of the day, that's a crucial point. So that because once I think the body has been established, I think a lot of the potential pitfalls that we have, I talked about, might fall away. So I think establishing who's going to be the right body to oversee this. And of course, then, thinking about all the safeguards that we have been discussing today, those would be important steps in order to ensure that transparency is actually increasing instead of, decreased.
Great, thank you. So, Nicholas, your turn.
Thanks, Jim. Now, of course, I would like to see this going to happen, but how? And I think there my wish would be in the context of the pilot project. We came across the Hantai, the Japanese system. So I like to see, some of the actors that are obviously, might become involved and that have been involved already in the pilot project. So like some patent offices, for instance, I've been talking to one recently, one very specific one, about this. And I like one of them, or maybe some of them, stick out their head and say, look, we're going to set up this at a very small scale, and let's see if it's going to work, if people are actually going to show interest, and we have close interaction with the European Commission and the ongoing process and so on. Because I think that, somebody doing a step here would move this whole thing forward. It might fail. I mean, the Hantai system is not going to be used at all, as we can see, but for other reasons, for some reasons. But and I'm saying that also because I strongly believe that there is a public interest here on the one side, which is clearly something that patent offices could and should be responsible for, but also I believe it's a business opportunity for some of them. So why not give it a try?
Great, thanks, Nicholas. Joachim, your turn.
Thank you, Jim. Well, I think one important thing is to also convince policymakers, because somehow the patent topic is something that's in the technical niche, and it looks like it's complicated technology, complicated law, but in the end, it's people in the Commission, it's people also in the Parliament, the European Parliament, deciding for the European Union about this, and to make clear that this is not, well, it is in a sense a topic for specialists, but it's a topic with pretty wide-ranging implications for the rest of the economy. So that's also something that I find is an important thing, and that from that then can follow the other things that, and of course the Commission is aware, so that's why we're doing this, but also other policymakers should be involved, because then it will be easier to implement all these things that we have discussed here.
Thank you. Brian, final points to you.
Sure. Thank you. I think I kind of agree with all three of the previous people before me who made some recommendations there. But just to follow up on the most recent one, I'd agree. I do think a broad recognition of the impact, reinforcement of that broad impact would certainly help, and the inclusion as for example, as the European Commission moves itself forward, addressing essentiality checks or SEP licensing issues more broadly, the inclusion of a broad community, even within the Commission itself. So, I guess what I'm really saying there is that certainly DG GROW has an important role, but so does DG COMP, because these are competition law issues, very much so. And that's why the horizontal guidelines consultation that's going on in parallel to a lot of what we're talking about is so important, as well as other DGs. This is, just really just agreeing there with Joachim about the broad impact and the wide impact, I guess. To add one proposed solution, one thing, it's a big thing, but I would suggest that building on that CWA 95,000 document that now my third time referencing, but it really is a very important foundation for behavioral norms in an SEP licensing context. And that document was built by licensees and licensors and large and small orgs, a very diverse set of organizations. But the normalization of the further normalization of behavior about how transparency can be advanced in a SEP licensing negotiation. And again, I would point to, I think it's a modest proposal. Sorry to use that, famous phrase there, but it's a modest proposal about the types of non-confidential information that SEP holders should be ready and generally willing at the get-go to share with alleged infringers / prospective licensees when they first notify. Things like a basis for their allegation of essentiality and infringement, including claim charts and other things like that. And there's more detail in that resource, but I would think that a normalization of behavior from that is from the ground up, from the community itself that is engaging on both sides of the table in this licensing, in SEP licensing would be really helpful if we can get it right.
Yeah. So yeah, a cultural change, I think, is what you're advocating. It would be good to know what you're buying. I think that's the kind of underlying issue. So before I finally turn it over to Morgan, I'd like to thank everybody in the audience and the participants for giving us a very fruitful and exciting and interesting debate this afternoon. I hope you agree that we've managed to shed some light on several issues which are still persisting in the intricate world of SEP licensing. And without further ado, Morgan, I will pass it over to you. Thank you very much. Oh, by the way, just one thing on that report that Brian's mentioned at least 3 times. I noticed that people in the chat room have been asking for the link, so rest assured we will send the link round afterwards. Thank you.
Thank you, Jim, and thank you all the panelists. To close off this webinar, lots of things being said, so I'll try to sum up the main takeaways. So maybe mentioning that, well, currently this assessment primarily take place in court cases, which means that disputes are about essentiality of the patents are already ongoing. And the fact that this happens so late in the process makes it really hard for businesses to properly evaluate the patents they're looking to license. So, but we must not forget that it's not just up to courts. We still have to identify the right bodies and the appropriate safeguards. We have to consider the role of SDOs. SDO's friend-based RPR policy will require contributors to disclose information about patents potentially essential to developing specification, and adherence to these terms by patent owners is paramount because, well, they know the patent best. And, well, we mentioned the practice of over-declaration of essentiality in SDOs impacts SMEs the most and further introduces lack of transparency and certainty in the SEPS framework. So when we can agree that SDOs should take further steps to address proper SEP licensing behavior, transparency must be prioritized in licensing negotiation that take place later on. And while in this context, the overuse of non-disclosure agreement mentioned earlier must also be factored in. Today, we've heard that while parties may choose to keep some negotiation confidential as part of normal commercial practices, basic information that can be important to facilitate fair licensing negotiation should not require confidentiality. And we've mentioned that document quite a few times, but the CWA 95,000 set of best practices provides some greater detail on the type of non-confidential information that good faith ACP holders generally should be willing to provide to prospective licensees. So ultimately, any independent third-party assessment is able to avoid bias or any unintentional harm is likely to be an optimal method to approach essentiality checks in a fair way. But anything that comes out of this check should not be binding. An ultimate determination of essentiality must be reserved to courts, but the quality of the work should be improved, and we should raise the overall steps examination everywhere, including courts. So it is up to the Commission's role to, well, better clarify how essentiality checks should be determined, but the European Commission should take into account this holistic view of the standards and SEPS licensing ecosystem before introducing any mandates for essentiality checks, even recognizing, as we've heard today, that separate but related issues within the standard and SEPS licensing ecosystem cannot be solved through essentiality checks alone. So in other words, it's really not simple. And the 2020 SEP pilot study recommendation reflects this too. So on that, I would like to express my gratitude to all our speakers, panelists for providing us with such stimulating discussion, and as well as a big thank to Jim for moderating today's event. And on that, I wish you all a very nice afternoon or evening. And just to stay tuned, we're having our third part of our webinar series on friend methodologies for SEPS valuation in January 2022. We'll provide more updates on the exact date. Thank you again. And bye.
Thanks for it all. Thank you.
Thanks, everyone.
Thanks, sir. Thank you. Thanks a lot.
Bye-bye.
Have a good day.
Bye.
Bye.